Okay, folks, the Turbine guy back one more time to discuss with you in Hennepin County, Minnesota, case number 27 CV 177166. That would be the neighbors Penny Rogers and Pete Lanfer versus the city of Orono and versus Jay and Kendall Nygaard and Go Green Energy. Okay, that's the case we're talking about. Right now, what we're going to talk about is what Orono asked for in their original claim. And I need you to understand this, Orono never ever submitted any paperwork saying they were changing what they were asking for, but what they were asking for in their original claim and what the actual order was. Of course, I don't want to show you that until we get there. Anyways, I've got the original claim here. It's called Defendant and Cross-Claimant, City of Orono's Cross-Claim Against Defendants. Counterclaim and cross-claim plaintiffs and third-party plaintiffs, Jay Nygaard, Kendall Nygaard, and Go Green Energy. Now, they start talking about the history and the applicable code provisions and blah, blah, blah. It's all a bunch of hoo-ha to try to hide what's going on, in my opinion. But now they get to history of code violations and code enforcements. You know, that is so deceptive because there has not been a history of it. But these guys just say it and the judge assumes there is. We have complied with the code all the time. And they're going to say, oh, the judge said this or that. But what we find out is that they leave out pertinent data which completely conflicts what their storyline is. We'll get into some of that as we go. Now, when we get to what Orono wanted here in their prayers for relief and their supposed counts, there's only one thing I wanted to point out to you, and it's ongoing enforcement efforts. And they talk about number 35, during the pendency of the above-mentioned litigation, blah, blah. The first ordinance was adopted, and the city replaced that ordinance with another. What they're talking about is their renewable energy ordinance and how it changed, okay? And they get to the bottom and they say, in the highlight here, under both ordinances, WEX and SWEX are prohibited in the LR1B zoning district. Well, what they don't tell you is after their date in here, of December 9, 2013, we had an order from Judge Bush in Hennepin County which stated, and was quite clear, that any person in Minnesota has the right to harvest the wind. So after he made his order saying any person did, they are admitting here that their ordinance violates his order. Not only does it violate his order, they make no mention on 1995 state law, which gives all persons in Minnesota the right to harvest the wind. It gives cities right to location and structure, which the city had no ordinances when mine were put in. Yet they continue to ignore the fact that we personally sued the city for our right to harvest the wind, and they made an ordinance one more time which prevents us from doing it. So their ordinance conflicts with state law, their ordinance conflicts with Judge Bush's order, and for some reason, their lawyers never mention that. So I just wanted to point that out. Now we get back to claims for permanent injunctive relief because we're such bad people. You know, even though they have a process they're supposed to go through in this city when there's a zoning code complaint, such as a city gets a complaint, the inspector determines is it a violation, then they try to work with the people, and if they can't, they might finally go to court. Okay, well that's not how it works here. Several items we're going to see on here, we were just sued for. They didn't ask what they were, they didn't ask why they were there, they make up their mind ahead of time and decide we're just going straight to court in violation of their own city established procedure that everybody else in Orono is subject to but the Nygaards. So, claims for injunctive relief. Permanent injunctive relief. Number 54, Nygaards have constructed SWEX on their property in violation of city code. One more time, in accordance with state code and Judge Bush's order, those were constructed. You know, just because they write a code doesn't mean it's legal. We've already had one of their ordinances. Actually, the only ordinance we ever challenged with Orono was overturned. We won that case. Yet Orono won't admit it. Nygaards are prohibited from constructing SWEX on their property. This issue was decided by Judge Marilyn Rosenbaum on May 10th, 2013. Well, I'm sorry, Judge Marilyn Rosenbaum, But Judge Bush afterwards said we had a right to have it. And you were overturned at the appeals court, and your ruling never stood, your second ruling, which was the same as the first, never stood the scrutiny of the appeals court because we lost on a technicality that was my lawyer's fault. Count 2, violation of lakeshore setback. That's just anything within the 0 to 75 foot. Violation of side yard setback, which is 10 feet. Permit requirement. Okay, now, I want to talk about those three at the same time. Not everything's a violation, and not everything requires a permit. If that was so, then there wouldn't be a basketball hoop in the city, because I can guarantee you nobody's gotten permits for basketball hoops. I was on the city council and planning commission. That didn't happen. People don't get permits for hot tubs. They just put them in their yard. Okay, that's a lot more dangerous than a flagpole kind of thing. So for them to just hold us to this strict covenant of this wording is so inappropriate and so unfair. It just doesn't match reality of the city. Okay, prohibited exterior storage. Nygaards are improperly storing various material, including building material, unconstructed sweats, and other items. That is blatantly false. We have never stored building materials on our property. We had dock equipment. We live on a lake. People on a lake have dock equipment and dock installation tools. I mean, that's just commonplace, and I've had these things here for decades. Decades. But they want to now come in after these neighbors move in and have been complaining about me for 8 years. Now they want to get me for stuff I was doing long before any of these people were at the city for the most part. Okay, now we get to their prayer for relief. Permanent injunctive, affirmatively requiring Nygaards to remedy all code violations. Well, there aren't code violations. We're either grandfathered in, they've missed their statute of limitations. There's so many reasons why this order is, well, in my opinion, surrendering to the city. In my opinion, the judge in this case completely surrendered to the city, gave them everything they want, and failed to do a fair and biased decision-making process as to whether or not things actually exist. And that's not really for him to do, because judges are not there to determine questions of fact. That's for a jury. So I think, like I said, my opinion, the judge completely surrendered to the city in an attempt to get us from getting to a jury. And we'll see some of his order for which I believe that. Okay, removal of all wind generators, SWECs, flagpoles, laundry drying equipment. Okay, they want all SWECs, all three, right? Laundry drying equipment. Well, I call those clotheslines. My mom never had a dryer. I grew up without a dryer. We hung everything indoors or out. Well, that's what I like to do too. But I guess I don't get to have clotheslines, or as Orono likes to be tough and call it, laundry drying equipment. All flagpoles. Well, I had some temporary flagpoles. I would switch them out here and there. A lot of people do that on their property. But the city of Orono, due to one complaint by the neighbors, Pete Lanford and Penny Rogers, wrote an ordinance saying that you can only have one lakeshore flagpole. Well, to me, that's a permanent flagpole. It's not temporary. People take and put down flags all the time, say for the 4th of July or whatever. But I'm not allowed to do that to express myself. So all my flagpoles gone. Wind generators. Now here's the fun part. If they knew the definition of a SWEC, what are they doing asking for wind generators? Same thing. Building materials. Like I said, we have no and have not had building materials on our property. We don't do that. Anything I do have stored in my garage. So there are no building materials. All offending structures. Well, this can mean anything to anybody. And it's a word put in there meant to inflame the judge. Instead of, like cities are supposed to be neutral and stand back and decide, not make things up and be inflammatory. And to me, that's what I see, is that this word was put in there specifically to inflame the judge. And that's pretty much what we see in 2 and 3. And if we, on page 13, if we look down, you can highlight where extra highlight where they say any other structures on Nygaard's property and the storage of any items on the Nygaard's property. Really? Any? Any and all. Any and all. Everything. Holy Christ. And one more time down below, I highlight offending. Like I said, that word was put in there specifically, in my opinion, to inflame the judge and make us look bad. Now, okay, part of what they put in their complaint was on May 7th, current status of violations. This is page 10. On May 17, 2017, city staff once again inspected property. It's amazing how many times we've been inspected, folks. I mean, I bet if you ask the inspector, the mileage just back and forth to here would be, oh my goodness, 5 miles to City Hall would probably be in the up to 1,000 miles. They're always inspecting us. Anyways, let's see, includes photographs of the offending structures once again, and items itemized as follows. Residential storage. Well, yeah, we stored our dock equipment and some dock stuff. That's what people do out here. Flag poles, too. Remember, 2 temporary flag poles. Discarded dock sections. Well, first of all, how do they know anything's discarded? Nobody ever asked me. So right there is an inflammatory word. And dock sections are something you have on a lake property, aren't they? I mean, you're a lake property. So, I don't know what that means. Pole and small wind energy conversion system. Small wind energy conversion system. So there's 2 different systems now. Pole / laundry drying equipment, poles / and a storage unit. Now if you notice, you know, their main thing didn't say any real storage unit in there, but they're sticking to their guns, offending, building material, all general terms to try to describe stuff in a manner in which it isn't. Okay? For instance, the storage unit they're talking about, okay, is something I put up over my 1954 Chris Craft in the winter in order to keep the rain and snow off it. I can't cover it normally because water will get in there, freeze and thaw, and wreck the wood, and I can't shrink wrap it because that seals the moisture in. So I have to cover it and let it set, and you know, with nothing on it, and that thing comes down in the spring when the boat goes out, and it goes back up in the fall, and that's what people do on the lake. They protect their boats. But according to Orono, okay, I have a storage unit, which this storage unit, they never followed city procedure on. I never got a notification letter. I just got sued. No one ever asked me what was in it. And it came up and down twice during the lawsuit. Okay, I don't know why the judge doesn't understand. I was on the City Council and Planning Commission. I understand quite well that you can't sue people for temporary items because they come and go. Okay, well, that shed has proved its temporariness by coming and going. And that was in the affidavits, but I don't really think the judge read what we put in. He sure as heck didn't believe us if he did. And I don't know why, because we sent pictures along with it. So, anyways, that's a perfect example of craziness going on here. Now, let's get to the order. Okay. But before we get to the order, you'll see injunction against J. Nygaard, Kendall Nygaard, and Go Green Energy, LLC. I'm going to make another video about Go Green Energy because this is outright ridiculous. Nobody has supplied any evidence that Go Green Energy has had anything to do with what my wife and I have done privately on our private property. Go Green Energy has nothing to do with whether or not I put up a flagpole, whether or not I put in my dock, how I protect my boat. That is so separate and different, but the judge has allowed now these people to defame my company and prevent me by getting business simply because they put the term in there and the city of Orono then put the term in there. Now my company has a judgment against it when it has not done a thing. That'll be a whole nother video. So that's the first problem I have with this order. And you know, it's number 4 and 5 in the injunction. Okay, so what the injunction basically reads, Go Green Energy is liable. I just went through that. We need to remove dock equipment from the 10-foot side yard setback. Well, I don't understand that because I've been storing it there for decades. Decades get you over 2. And everybody else does. I went and took pictures of all the properties on the point, and everybody else has it pushed off. Both neighbors do. The guy across the street, the mayor who lives a few houses up, all have dock equipment stored within the 10-foot side yard setback. But now we have this order that we have to remove our dock equipment. Construction items. One more time. There never were any construction items on the property. I mean, I don't know why they can just make stuff up and the judge goes with it, but I guess that's what happens when you give up and surrender. Okay, a 10-foot spruce tree with flagpole. First of all, there is no 10-foot spruce tree on our property. The thing's well over 20 feet. It's in the 0 to 75-foot setback and the DNR 0 to 50-foot setback. Both Orono and the DNR have a regulation preventing me from chopping that tree down because of where it's located. But now I have a judge ordering me to chop a tree down. Now if you look anywhere in here, there is nothing about a spruce tree anywhere. Nothing. I'll write this right. Okay? Nothing. So, it's quite confusing to me because the order doesn't match what they asked for, and they never asked for a spruce tree as they went through. Even though they changed the lawsuit, they never asked for a spruce tree. Wind turbine assembly from 10-foot setback on the uphill side and one on the downhill side. Okay, 1.9 foot radius turbine assembly. Okay, it doesn't say anything about the pole, it doesn't say anything about the footing, just a turbine. So I bolted it, disconnected it, and I moved both of them out of the 10-foot setback. That'll be another video. I'm going to walk around and show how we've complied with this order. Brackets for a flagpole on a shed. What? There was no mention anywhere here of brackets on a flagpole in a shed. The city of Orono never changed or moved to change a lawsuit to get rid of it. What ended up happening was when they came out to do their survey, okay, I removed a couple of flagpoles to prove that they were temporary. Well, the city then changed a lawsuit to say, well, he's got to remove those brackets. So I removed the brackets. I'm complying with the order. That's what I do. But I don't understand, one more time, how brackets became a part of this lawsuit just out of the blue. Makes no sense to me. Makes no sense at all. Okay? It says a steel clothesline pole. Now they asked for laundry drying equipment, and in their thing they asked for both poles, but the order stated specifically, you can see it right there on the next page, a steel clothesline post within the side yard setback. A, 1. A means 1. Okay, and last but not least, well, see, here's a portable soft-sided storage structure. This thing's got all kinds of questions. This order has questions because it doesn't match what they asked, and there's all kinds of reasons we should be keeping it, such as it was in during a previous lawsuit it was mentioned in, that'd be res judicata. Even the current Orono ordinance regarding clotheslines, which they call laundry drying equipment, doesn't give a setback. Okay, they have one, but it gives no setback. And those were installed before any setback was given. And these would not have needed a building permit, just like basketball hoops. And that was actually wording of an appeals court order that flagpoles, basketball hoops, and clotheslines populate the city without control. Well, then why am I all of a sudden controlled now when they were installed before that ruling? Crazy. And the portable soft-sided storage structure. Now the last thing has me somewhat confused as well. We'll remove all non-trash items. Non-trash items. Okay, well, I've got a list here. We can go over this quickly. And, you know, the crazy thing is, if you'll remember on my other video with the inspector, I went through this list with him, and he agreed with me that he was there to take pictures, and he took no pictures of anything on this list. And why wouldn't he? Because there wasn't anything. And I've been telling the judge that. I've been telling the city that. I've been telling everybody. Now, here's what non-trash items are. Accumulation of wood pallets. Never had them. Accumulations of vehicle parts or tires. Nope. All construction and building materials. I've said repeatedly, there are no construction or building materials on our property. There haven't been. It's dock equipment. It's dock equipment. It's dock equipment. It's dock equipment. All appliances and appliance parts. Well, on the odd occasion, I've had like my water heater outside for a week or so till I could get it down to the scrapyard. But, you know, nothing's ever really sat out there. And they don't have any pictures of any. All indoor or upholstered furniture of a type which is deteriorated by exposure to the outdoor elements. Nope, never had any. All recycling materials except for reasonable accumulations amount consistent with a policy of regular removal, which is exactly what I do. I keep some of the stuff from different jobs or whatever, and when I get 500 pounds of metal, down it goes. I get a bunch of batteries, down they go. And I usually go down 2-3 times a year. All other non-trash items, which are type, quantity inconsistent with normal use. That's where docks come in. Okay? Docks are consistent with the normal use, so that stuff gets to stay. A type and quantity consistent with the intended use. Well, that's up to me to decide for the most part. And are likely to obstruct or impede necessary passage of fire or other emergency personnel. I don't store anything where I'd be impeding fire personnel. It doesn't really matter anyways. We've got a fire lane on the end of the street. They can go dump their suction hose in, and they're all set to go. So, inspector took no pictures of these, which means there's none of them there. So we're covered on the non-trash items. That has been up and down repeatedly and has been down for over a year. We removed that. Brackets. We'll go through, you know, I'll do a video and go show you all this. But look at the difference. That's what this is about. Look at the difference. All 3 SWECs. The judge ordered 2. Because during the lawsuit, Orono changed it from 3 to 2. They didn't want to go after the one on the house because they knew they would lose given Minnesota statute and Judge Bush's order. So they played a game with the judge to ignore our state-given right. So instead of 3, it's 2 now. Laundry drying equipment, which I call clotheslines. Okay. All of it, we only had to remove 1. All flagpoles. Well, wait a minute. According to their even new ordinance, I get to have one. But they wanted all flagpoles removed. Wind generators. Well, they're the same as SWECs. I don't know why it's in there twice. Building materials. One more time. Dock equipment. We never had building materials. Okay? All offending structures. You know what? Let's just inflame the judge and make these guys look bad. Whether or not they're right or wrong. So, there you go. 3 to 2. And let's look at it from this way. Dock equipment. Okay? They don't say, they don't say dock equipment anywhere. But that's part of it. Construction items. Never were any. He wants a 10-foot spruce tree down. Wait a minute. There is no 10-foot spruce. And they never asked for a tree to be cut. And I can't cut it or they'll go after me for that. Wind turbine assemblies, okay, that 2 out of 3. Brackets for temporary flagpole. Brackets were never mentioned anywhere, but the judge put it in there because they changed the lawsuit midstream without going through proper procedure. A steel clothesline pole, well, 1 instead of 2, we took it down, and the soft-sided storage structure, I don't get to protect my boat. Everyone else gets to protect their boats in Orono, but I don't get to, and non-trash items, which goes along. Well, I gotta say, I'm quite dismayed, especially for the permanent injunction. The city already has a process in which to deal with code violations. To get a permanent injunction where they simply get to put us in contempt of court if they believe or they think or they just want to, then we're screwed. And that's what this is all about. The heavy hand of the city, the heavy hand of the courts trying to punish us, in my opinion, and to smack us down from standing up for our rights. And that's the way they're going to do it, is by to keep putting us in contempt of court instead of allowing us due process like everyone else has from here going forward.